But is the problem with the existence of harm or non-existence of harm, or is the problem in what is the best way to deal with marijuana?
Well,
in other words, to put it bluntly, what is the best way to deal with the social concern over the use of marijuana? It may be somewhat far-fetched, but some years ago, attempted suicide was a crime, and this was removed from the criminal code. My understanding is largely because it was felt that the criminalization of attempted suicide was not the best legislative approach to dealing with that problem. I think there was no question that attempted suicide is harmful. It was a question of ways and means of dealing with the problem. And I think in this case, perhaps one has to question oneself as to the level at which we're dealing with is it at the harm level, or is it a way of means of dealing with harm? And when you see all these many reports, I think they reflect questioning as to the ways and means of dealing with harm. I'd like to hear you on that.
Part of the foundation for the harm principle is that it's Parliament's decision to use criminal law that then engages the harm principle. In other words, if it were regulated and it didn't have the attached criminal sanctions and criminal stigma, the harm principle wouldn't be at play, at least in the appellant Clay submission. So really, I think we're saying the same thing, that in terms of assessing whether or not the criminal sanction as a response to the social phenomena is proportionate, to use the language of, say, the most recent Commons Committee report, you still have to examine, well, in assessing proportionality, you have to say, well, what's the harm that you're trying to prevent? What's the harm that the criminal prohibition on marijuana is trying to prevent? And do you really need a criminal prohibition? Can't you come up with a less severe way of dealing with the problem?
But that raises the question, is it up to the court to decide that, or is that a political question which should be left to the elected representatives in Parliament?
Well, because the criminal sanction clearly engages Section 7 interests, it very much is up to this court, because at the end of the day, there are still hundreds of thousands of Canadians whose Section 7 liberty interests, if nothing else, if you don't accept what Mr. Conroy has to tell you later, at a minimum, their Section 7 liberty interests are engaged. And if, in fact, the record, as we say it does, shows that there's an insufficient amount of harm to warrant the very heavy hammer of the criminal law, then it is for this court to interfere, because then what you're basically finding is that these individual Section 7 liberty interests are being affected in a disproportionate manner. So let me touch on the other points that I had briefly about why deference is not appropriate. It's important to note, as I was saying, that the Royal Commissions have almost universally recommended decriminalization. The findings of the Laurel Commission are significant. Even if it were as close or as low a threshold as proposed by the majority of the BC Court of Appeal, it's important to note in Laurel, the Laurel Commission concludes, and this is at paragraph 50 of our joint statement of legislative facts, that there was no evidence of long-term physical effects. And further, and this is in our record at volume 15, page 3040, I won't ask you to turn it up, the Laurel Commission also concluded that from the point of view of lethal toxicity, cannabis must be considered one of the safest drugs in either medical or non-medical use today. It was in light of those findings that Laurel ultimately recommended that that Parliament had to decriminalize the simple possession of marijuana.
Don't we have to, though, proceed on the basis of the findings courts have said below about harm? And shouldn't you be focusing on that instead of what commissions and so on have done, because this isn't a roving commission. This is not just commission number 4 or something. We are in a court of law. We have to deal with what were the findings below. So this is all very interesting, but you can spend your time as you wish, but we're really going to have to come to grips with the findings below at some point.
Well, even in the courts below, it was abundantly clear, unanimously, Justice Howard in Caine, Justice McCart at trial in Clay, as approved by the Court of Appeal, there was a finding that there was no harm associated with the moderate use of cannabis. And that defined the vast majority of users of cannabis. There's different numbers that are floating around, but even in the most recent Special Senate Committee report, the suggestion was that 95% of users of cannabis are nothing more than moderate or occasional users, and therefore even the long-term occasional or moderate use will not cause any harm to the user. So that is a finding of fact. And in my submission, when we're then measuring the significance of the harm, we have to bear in mind that we're talking about a very small segment of the total quantity of users.
But is that segment not significant in terms of legislation? In other words, legislation is in good part intended to protect those who are most vulnerable. The person who is in excellent health, is well balanced and so forth, probably doesn't need legislation either to protect him or herself or to protect others from the actions of that person. But often criminal legislation is aimed at those who find it difficult to act in a socially responsible way.
But the fact remains that for every one person who might need help, because even with respect to the groups, quote unquote, at risk, it's not as though everyone in that group is going to be harmed. At best, the evidence, even as found by the courts below, shows that there's been some evidence of a risk of harm. So you can't necessarily say even that everyone in that small subpopulation will be harmed. But in any event, for everyone who might be harmed, you have 20 others who you know are harmed by the criminal law, even though there's no harm, zero, done by their conduct. Because the other 20, the other 95%, are moderate users whose use of marijuana causes no harm to them and no harm to society.
And even the moderate user would be, use the word impaired, and while he's not hurting himself, he could be a danger driving a car.
That, while it's certainly a putative concern out there, it's left ill-defined. Nobody has, first of all, we have the offense of impaired driving. None of the courts below, in my submission, somehow suggest that it's a significant percentage or in any way increases the risk measurably. There's simply no evidence out there to suggest that it is a pressing social. Sorry.
No statistics.
But
wasn't it generally, seemingly at least, accepted that it impairment factor that precluded or should preclude people from using certain types of equipment as a protection to the public?
Absolutely, and the evidence in the record shows that in large measure, people who smoke cannabis don't want to get behind the wheel, or they're certainly nowhere near as dangerous as obviously drivers impaired by alcohol, or they're relatively safer than drivers who are doing other things in the car, like driving with their cell phones. So in terms of somehow saying that somehow measurably increases the risk, we're talking about, at the end of the day, in my respectful submission, about the subpopulation that the courts were concerned about, where there's been some demonstrable risk of harm. And
wasn't that something between 30 and 50,000 people?
As compared
it's a relatively small percentage, but in absolute terms, it's quite a lot.
Agreed, except that you can't, in my submission, divorce that from the other findings of fact that the court makes. And I don't want to repeat myself because I know I have limited time, but so you have to say, okay, well, at 30 to 50,000 people, but at the same time, you are causing more harm to 20 times more people. And again, those people are causing no harm to society.
Can I just stop you there? This is what's troubling me, and I'm not sure I have your position. Earlier on, you seemed to suggest that the test is whether the law has a rational basis or foundation. Now that we're in an argument, you're saying it's a proportionality sort of thing, that Parliament has to get the equation right. They have to show that there's more harm going to be caused by decriminalization than by criminalization. That's a very different test. And to get back to the examples, if there's 30 to 50,000 people who might be in that category, what's troubling me is that that may be sufficient to give a rational basis for the legislation, even if one can argue about the proportionality. And if that is clear, then isn't that within what Parliament can do?
Thank you, Chief Justice, and you're quite right. I'm mixing two parts of my argument in answer to the questions. There is, we say that the deprivation of liberty does not accord with the principles of fundamental justice, either because of the harm principle and or because of very well settled doctrines in this court, that is overbreadth and or irrationality. The overbreadth analysis and the rationality or irrationality arguments are independent of the harm principle. That is, they're not one and the same, as you quite correctly point out to me. I say that the criminalization of the 950,000 users in order to protect the potentially at risk 30 to 50,000 users engages the overbreadth doctrine. It's almost exactly like the situation in Haywood. In this court's decision in Haywood, you had a constitutional challenge by an individual who was claiming that he had a liberty interest in choosing the location of where he was going to engage in recreation. That is, he wanted to go to certain parks or community centers, etc. And this court found that because, I believe it was then Section 161 of the Criminal Code, because it overstepped the mark, that is, it prohibited him from going to places where he couldn't cause any harm, places where there wouldn't be any children, that because it engaged his liberty interest, by virtue of it being a criminal punishment that would attach to it, and because it overshot the mark, it prohibited him from engaging in recreation even when he would cause no harm, this court held that Section 7 was violated in terms of it not being in accordance with the principles of fundamental justice.
Couldn't you make the same argument against the prohibition of handguns?